Now again we have taken a very important, interesting topic. It is not a very big topic, but it is an interesting topic. One constitution bench to function year round. Now the existing Chief Justice of India, N.V. Ramanna, has retired on 27th of August, and the incoming CJI, that is UU Lalit, he has been sworn as the Chief Justice of India. That is one news. Now who is the Chief Justice of India? UU Lalit. Honorable UU Lalit is the Chief Justice of India. On 26th of August, he said that there will be at least one constitution bench in Supreme Court throughout the year. Okay. Now Supreme Court is having a lot of vacations, right? But vacations do not change the fact that Supreme Court is having pendency of around 75,000 cases, which was 57,000 cases in 2017. That means the pendency of cases in Supreme Court is increasing day by day. Moreover, a very important point that we need to notice here is the bails and the issues related to personal liberty and life. They come up regularly in the Supreme Court. For that, it is important that the court is running all the time at least. But the court is having vacations, for example 2-month vacations. There are vacation benches as well. But the vacation benches as well, there are vacation benches, but the normal functioning of the court is not happening at that time. So the Honorable Chief Justice of India, UU Lalit, he said that he will try his best to ensure that at least one constitution bench is continuously running throughout the year. Okay. Now, what is the background? Let's have some background on it. As I already told most of it, Justice Lalit's initiative comes at a time when we have around 71,000 pendency in cases pending in Supreme Court itself. Okay, which was around 55,000 in 2017. But the effect of Corona has also led to increase in pendency because the court was not running at normally at that point in time. Okay. One important reform, judicial reform, which I would say is that Supreme Court is also going to live stream its proceedings. Supreme Court is also going to live stream its proceeding, and that will be a great way to democratization or opening up the court. Although Article 145 clearly says that no judgment can be issued in a closed court. That is, the court is always open. But that does not ensure that court is easily the proceedings of the court can be seen by everyone, because the court is of course a very limited space is there. Everyone cannot go there. One needs to have a pass to go there, right? But no judgment can be issued in a closed court. Any judgment that is being issued must be issued in an open court. That is mentioned in Article 145. Okay, he also said that, and one important point that he mentioned is that the urgent matters, he will also put in place a mechanism that would allow the lawyers to mention specific cases of very high importance, like those with bail and such important urgent matters. Okay, there will be such a mechanism that they can be easily put forward for a judge to be heard. Okay, what happens usually is lawyers run across the judges' chambers. Okay, sir, let's kindly mention my case. My client is having this specific problem, and then judge looks at the case, and if it is a case where the personal violation of Article 21 is happening, then it gets listed in on urgent basis. Okay, but do all these cases get mentioned like without a law? No, there is a specific roster according to which these cases are mentioned. Now let's look at what is a constitution bench. A constitution bench is a bench of Supreme Court having 5 or more judges on it. So it is mentioned in the constitution clearly that any matter that leads to interpretation of the constitution itself, that will be a constitutional case, and that case can only be heard by a bench. Bench means number of people, number of judges who are presiding on a case, on a bench that has at least 5 members on it, that has at least 5 members. Okay, these benches are not routine phenomena. Okay, the constitutional benches are not routine. Whenever a constitutional case comes up, they are formed. A vast majority of cases before the Supreme Court are heard and decided by 1 bench, 2 bench or 3 bench. Okay, basically 2 or 3 bench judge. ठीक है, तो one important point here to note is कि any judgment that has to be delivered is to be delivered by majority of the bench. ठीक है, for example, there are two judges, so the 2 judges have to agree or to reach on to a decision. If the 2 judges are in disagreement, then the decision cannot be reached, and then it will be referred to a higher bench. Okay, then also a constitutional bench can be formed. Okay, Chief Justice of India is the master of roster. See, there was a lot of controversy, there was a lot of conflict over this master of roster when Justice Deepak Mishra, Chief Justice of India, Justice Deepak Mishra mentioned clearly that the Chief Justice of India is the master of the roster. He is the person who will allot these specific cases to specific benches and specific judges. Okay, he said that the Chief Justice of India is the master of roster. That is, the allocation of cases to specific judges or specific benches cannot be random. It has to be done by the Chief Justice of India. But that does not mean that Chief Justice of India is having some special privilege vis-a-vis the other judges. It only means that the Chief Justice of India is first among the equals. Like Prime Minister of India, he is first among the equals. Okay, now you can have a clear view of Supreme Court of India. This is Supreme Court of India. Okay, now let's look at some constitutional provisions dealing with the constitutional benches. Article 145 says that this master of roster, okay, that does not come from vacuum. It comes from a specific law. That is Article 145. Parliament and Supreme Court both can make laws or rules regulating the procedures inside the Supreme Court. That means Supreme Court itself can also make laws to regulate the procedures of the court. But when the Supreme Court makes laws, they will have to be ratified by the President. Okay, they will have to be ratified by the President. The minimum number of judges who are to sit on the purpose of deciding any case involving a substantial question of law. Now that is important. What is substantial question of law? Substantial question of law means any case where there is a question as to decide if the law is in itself valid or not. If the law is in itself valid or not, or if the interpretation of some clause of the Constitution is itself required. In that specific case, the minimum number of judges who are to sit on that specific case will be 5. It will be 5. Okay. Now, one important point here is, or for the purpose of hearing any reference under Article 143. Now, Article 143. What is Article 143? Now, I hope you understood that Article 145 talks about 2 important things. The first one is the minimum number of judges in any case which requires the interpretation of Constitution itself, okay, or which has any case where there is a need to interpret the constitutional clauses, or where the judges need to see if the law itself is valid or not. In that case, the bench cannot be less than of 5 judges. But the second point of this article also talks about the fact that whenever there is a reference under Article 143. Now 143 talks about power of President to consult Supreme Court. President can refer any question of law or fact to Supreme Court. Okay, and while deciding on that reference made by the President, the strength of bench cannot be less than 5. That is what is written here. Now 143, President can refer to Supreme Court any question of fact or law, both of fact or law, to the Supreme Court. And one important point is the Supreme Court is not bound to give its opinion. Secondly, the president also is not bound to accept the opinion of the Supreme Court. Okay. Now, president can also take Supreme Court's opinion in any matter related to disputes of the federal nature, notwithstanding Article 131. Notwithstanding the provisions of Article 131. Now, what is Article 131? Article 131 talks about the exclusive jurisdiction or the original jurisdiction of Supreme Court in matters of federal disputes. Federal disputes means if there's a dispute between two states, if there's a dispute between the state and the center, or if there's a dispute between some states and the center, then such disputes are called federal disputes. And Article 131 says that any such case, any such dispute is to be only heard by Supreme Court. Even high courts cannot get into adjudicating over the federal nature, the disputes of federal nature. That can only be heard by the Supreme Court. Okay. President can also take the Supreme Court's opinion, and President can also take the opinion of the Supreme Court in a case where a dispute between state or center has arisen. So it says that in both the cases, if the Supreme Court is in both of the cases, when the president has made a reference to the Supreme Court, then the Supreme Court, the number of judges who will sit on in making such a judgment in both the cases will be not less than 5. That means these two questions are constitutional questions. That is why a 5-bench judge can only sit, or more than 5. Okay, I hope you understood that. Now let's do a previous year question. It was asked in 2021, very recent. Now question is, we adopted a parliamentary democracy based on British model, but how does our model differ from that model? I have time and again asked people to go through the comparative analysis of India's constitution with other constitutions, most importantly with British and American. Now let's look at point 1. As regards to legislation, that means with regard to the lawmaking, the British Parliament is supreme or sovereign, but in India the power of Parliament to legislate is limited. Now, is that a correct thing, or is that a incorrect thing? See, in Britain, the constitution is not a written one. The constitution is not a written one. It is an oral constitution. And Parliament is the supreme body. The Parliament, whatever Parliament makes becomes law. Whatever Parliament makes becomes law. That means Parliament is having unbridled power to make a law. The Parliament is having unbridled power to make a law. But that is not the case with India. In India, Parliament is sovereign, no doubt, but it is not supreme. It is not supreme in the sense that under article, like in Keshwanand Bharti case 1973, Supreme Court said that, Supreme Court opined that under the constituent power of Parliament, constituent power means the power that it derives from Article 368, of course, and the constituent power basically implies that when the constitution was being made, it was made by Constituent Assembly, but Constituent Assembly was dissolved. So the power to make any change into the constitution was also transferred to the Parliament. That power through which it makes a change into the constitution itself, that is called constituent power. Okay, so using that constituent power, what it does is the Parliament amends the constitution. But can it amend all of the constitution, or is there a limit on it? To answer that, the Keshwanand Bharti case 1973 is very important, because in that case Supreme Court actually Supreme Court put forward this opinion that the power of amendment of Parliament for constitution is immense, it is unlimited, given the fact that the basic feature of the constitution is not changed. And hence it naturally implies that the power of amending the constitution is not unbridled, is not unlimited, it is limited by judicial scrutiny. it is limited by judicial scrutiny. Now that means statement 1 is correct. Now we have either C can be answer or B can be answer, right? Or A can be answer. Now let's look at option 2. In India, matters related to the constitutionality of Amendment Act of the Parliament are referred to the Constitution Bench by the Supreme Court. Constitution Bench by the Supreme Court. Okay. In India, related to the constitutionality of an amendment of the Constitution itself. Okay. Parliament are referred to the Constitution Bench. Anything where the constitutionality is checked, that means that is a specific portion which invokes the provisions of the Constitution itself. Okay. In that case, the Constitution Bench will preside. In that case, Constitution Bench will preside. No other bench can give a judgment on that. Okay. Okay. That means both 1 and 2 are correct. Hence, option C is the right answer. Okay.